As per the office note dated 18/12/2024, Worship, the notice we have served upon a respondent number, it was returned unserved. The remark was no such person is found on the given address.
Served through what mode?
Registered post, my lord.
You send it through the officer in charge of jurisdictional police station.
Jurisdiction of the police. Lordship,
Take it.
Lordship,
Take,
yes, Lordship. Lordship, the address is in Assam, my lord.
still it can be sent.
Lordship. And also, Lordship, there's another criminal petition pending before this honorable court. And that criminal petition is being filed by this present respondent number 1.
Where he is appearing.
There, yes, my lord. There, in fact, we got the address from that criminal petition which he has filed.
Is it connected?
Lordship, yes. In fact, it is, my lord.
Connected?
Yes, my lord.
How?
Because that one is for that criminal petition is filed by respondent number 1 for quashing of the criminal proceedings. And here we have filed this petition under my lord, under section 340 of the CRPC, praying for initiation of proceedings, my lord.
Same
Ye-
matter.
yes, my lord. Same parties are represented here, my
Parties
lord.
may be same, whether the matter is same.
Yeah, lordship. In fact, lordship, what my point is, my lord, there's a council representing them in the other criminal
No,
petition.
we may
So if
fix
that,
this matter along with that matter.
lordship, that is also okay, my lord. I'm okay with that also. However, I have been trying to get in touch with the council representing them in
No,
the other.
therefore what I was asking.
Yes, my lord.
That whether the matter whether the PS case, police
Yes, my
station
lord.
case.
Yes, my
This
lord.
case as well as the case which you are referring.
Yes, my lord.
Same,
Yes, it's connected, my lord.
same or
Yes,
it is same.
it is connected, my lord.
No, what is being meant by connected?
In that criminal petition, my lord, they are praying for quashing of
Of
the FIR,
which
of the
FIR?
criminal proceedings, my lord. My lord. No,
Heard
apology, my lord.
Ms. Luchino, Learned Counsel for respondent number 2. Learned Counsel for the petitioner has submitted that the petitioner has taken steps for issuance of notice on the
Uh,
respondent number 1 by registered post with AD. However, the office note dated
18/12/24, my lord.
18/12/24 shows that the notices issued to the said respondent has returned without service with a remark within inverted comma, no such person returned to sender. Stop. Learned Counsel for the petitioner has submitted that the respondent number 1 has also preferred another criminal petition, that is
Criminal petition number 18 of 2024, my lord.
petition number 18 of 2025,
Yes, my lord.
where his engaged counsel is appearing before this court, and she submits that the matter involved in this case is connected with the
Yes,
matter of the said criminal petition. Hence, she prays that this matter may also be fixed along with the aforesaid criminal petition. Stop. Considering the office report referred herein above, as well as submissions made by learned counsel for the petitioner, prayer is allowed. Let this matter be listed along with criminal petition number
18 of 2024.
18 of 2025,
24, my lord.
2024,
Yes,
on a date to be fixed by registry.
my lord. Obliged.
For orders, item number 19.
May I please, Your Lordship? My Lord, I pray that I may be allowed to mention orders item number 20, since notice is still awaited.
This is item number 19.
Lordship, yes, they are going to take some time, so I have some work. If I pray that,
Call item number 20. Who is the counsel for item number 19? It will take time.
Yes.
Okay. Yes, 20.
For orders, item number 20.
Lordship, notice upon the respondent.
Yes, what is your name?
Ping Hombin is on, I'm appearing on behalf of my senior Joshua Shekia.
Please write her name. Learned counsel appearing on behalf of Mr. Joshua Sheki, learned counsel for the petitioner. It appears from office note dated 11/3/2025. That notice issued to respondent number 1 to 4 have notices issued upon respondent number 1 to 4 have not yet returned. We will await.
Lordship,
We will,
yes,
we will wait for some time.
yes, Lordship.
Stop. Await service report list after 2 weeks.
Lordship. Obliged, my Lord.
For orders, item number 19.
May I please, Your Lordship.
Testing.
Though
This is a civil revision.
yes, Lordship. Though the matter is listed for order, if Your Lordship may kindly see the last order on 10 March 2025, the case is fixed for admission hearing for disposal. Actually, Lordship, when the matter revision was moved on 21 February 2025, this honorable court, instead of hearing the interim, this court's opinion was that we should go for expeditious disposal. Accordingly, my lord, the affidavit has been exchanged and the LCR also has come. So the matter can be disposed.
Records of, where are they?
Yes.
Tomorrow you shift this screen little bit. I have to see your glasses. Yes,
My lord, this revision petition is directed against the order dated 2012-2024.
yes, yes.
My lord, an order was passed on 2012-2024 that, however, the final judgment was delivered on 14/1/2025. The 2012-2024 was the last working day, so the learned appellate court has passed a short order that then judgment was delivered on, final judgment came on 14/1/2025. No, my lordship, this is the order passed in first appeal F number 2 of 2024. Passed by the learned district and session judge Dimapur. This arising out of IA Civil 388 of 2024 was by the learned Civil Judge Senior Division Dimapur, arising out of civil suit number 23 of 2024.
No, you are impugning the order dated 2012-2024.
Lordship, yes.
That is the impugned order.
Yes.
But after that, the case has been finally disposed of.
My lord, if
By
Lordship,
14/1/2025.
yes, the final judgment, the detailed judgment came on 14/1/2020.
So matter has been disposed of by.
Yes, yes, yes. So I'm challenging as a matter of abundant caution, Lordship, I'm using the order that I'm praying for caution of setting aside the order dated 2012-2024, by which the temporary injunction was vacated. The vacation order, a short order was passed on 2012-2024. The detailed judgment was delivered on 14/1/2025.
You are not challenging the,
Vote. I'm challenging vote.
in this
Yes,
revision.
yes, I'm challenging vote. Lordship, may kindly allow me to show.
What
Lordship,
was
may
the matter? What was the matter?
My lord, kindly allow me 5 minutes, because there's a long checkered, there were a series of litigations, there are 6, 7, that's why kindly allow, in a gist, I'll highlight the facts in 5 minutes, and I'll go to the judgments. Lordship, the issue relates to election to the post of President Sumi Ho.
Me, ho, ho.
Sumi Ho.
What is this?
Lordship, Sumi Ho is the apex socio-cultural organization of the Sumi tribes in Nagaland. Now, Lordship, they have a constitution. They have their own bylaws. And every 3 years, they conduct their election. It is something like Satya, Ahom Satya Sapa.
Okay.
Lordship is well aware that the Sumis are one of the major tribe in Nagaland. Besides, in Nagaland, you'll find Sumi villages in Assam as well as Meghalaya. So, my lord, for all the community, they have an organization called Sumi Ho, that is the apex tribal organization of the community lordship.
Yes.
Now, lordship, we have a constitution. My lord, I'll be referring to the provisions, but just in the gist so that, lordship, for easy understanding. We have a constitution. Now, under the constitution, every Sumi member's individual is a bona fide member. Every Sumi person is a citizen, is a bona fide one. I'll show the constitution. So, my lord, then, lordship, they have, for every 3 years, they'll appoint a nominating committee, and the nominating committee will recommend for the office bearers to be elected, because if there are more than one aspirant, then there will be election. If it is less than one, then lordship it will be selection.
No.
If it is less than one, I'm saying. If it is only one, I'm sorry. If it is only one, if it is more than one, then so they will recommend, then it will be selected for the post of one. So president, vice president, general secretary, assistant general secretary. Then you have an executive council. So
Now, these office bearers are nominated by whom?
Search committee.
They'll be nominated for search committee, or nominating committee, whatever. My lord, I'll refer to the constitution. So, my lord, there, my lord, everything will be clear. But just a summary submission I'm making, without referring to the documents. So the search committee will recommend, and then the general body meeting will be held, and they'll approve the recommendation. Now, for the post of president and vice president, as per the constitution, the minimum requisite age should be 50 years of, one should be minimum 50 years of age to be eligible to be considered. For the post of general secretary and assistant general secretary, it is 40 years. And lordship, another important issue is a person, whoever is selected as an office bearer, is entitled to serve for maximum 2 terms.
Okay.
And also, lordship, to be eligible to be considered for the office bearers, one should be a member of the executive council.
Executive council.
Executive council. Only from amongst the members of the executive council, the office bearers will be nominated or selected, whatever. So that is the sounds in support of the
How many
constitution.
members are there in executive council?
49.
49.
Who selects them?
Malat, the respective regions.
The
Not
Okay.
regions, Lordship, respective constituencies,
Respective constituencies. Malad
constituency,
does.
areas, or
That's why I-
semi-areas.
So many areas, so many region, Malad, all the same. In my, the constitution I will be highlighting, so everything will be black and white, Lordship. No problem for that, because everything is mentioned in detail in the constitution. But for easy understanding, I'm just trying to highlight so that you can, Lordship will grasp the issue easily. Then, Lordship, for the tenure 2024 or 2027, for period of 3 years. Lordship, the search committee has submitted a recommendation on 25/7/2024. And it was approved by the General Council on 26/7/2024 for the tenure for the 2024 or 2027. Now, Lordship, the dispute, the subject matter of the civil revision is relating to the selection up to the post of president, who is the respondent number 2 in the present case. Lordship, after he was selected, Lordship, thereafter, my lord, the petitioners, some of the petitioners had doubted his date of birth, that he is not 50 years for the post of president.
Okay.
Lordship, he was the incumbent general secretary. The present respondent number 2 was the incumbent general secretary, and he was recommended, and he was thereafter selected. So, my lord, RDI was, and prior, Lordship also kindly appreciate this fact that prior to his appointment as general secretary and president, he also had earlier served as assistant general secretary and general secretary for two consecutive terms. The present private respondent number 2, who is now the president. He served as assistant general secretary, then general secretary, 2 consecutive terms. Thereafter, there was break. Then he was appointed as selected as general secretary, now president. So he's serving for the fourth term as office bearers of the Sumi Hoho. Now, Lordship, the petitioners filed RTI applications to inquire about his date of birth.
Date of birth.
Date of birth. And, my lord, in terms of the RTI replies, which is enclosed, in terms of his official documents, that is his matriculation certificate and his driving license and his service records. He was serving in the education department and he took voluntary retirement. So those 3 documents were obtained. Now, on the basis of those official documents, my lordship is well aware that our date of birth is on the basis of the records in the matriculation, as entered in the matriculation certificate or in the admit card for all of us. So, in terms of those official records, his date of birth was as on 29/6/1977. So he had not completed 50 years of age.
When?
As on 25/7/2024, when his name was recommended. In terms of the documents, in terms of his official documents.
Okay.
So, my lord, the petitioners before you, the appellants before you, the civil revision petitioners had filed, lordship, civil suit 23 of 2024 in the court of Civil Judge Senior Division, Dimapur, which was admitted on 27/8/2024, lordship. It was admitted on 27/8/2024.
Yes.
And the plaintiffs also filed interlocutory IA 388 of 2024 praying for temporary injunction of the selection of the respondent number 2.
Okay, what happened?
Lordship. Also, Lordship, after we filed IA3, the plaintiff had filed IA 388 of 2024, the respondents herein, who were also respondent in the civil suit, had also filed IA 455 of 2024, challenging the maintainability of the civil suit.
Okay.
Maintainability of the civil suit was challenged on the ground of locus standi, jurisdiction, that there is no cause of action, that there are alternative remedies available, and also non-joinder of necessary parties. These are the broad 4 or 5 grounds, legal grounds on which this IA was filed on 455 of IA 455 of 2024 was filed by the present respondents. Thereafter, Lordship, put the IA 388 and 455 was heard by the learned trial court on 29/10/2024. It was heard together, Lordship.
Yes.
And Lordship, a temporary injunction under Order 39, Rule 1 and 2 was granted by the order dated 18/11/2024.
Yes.
And the maintainability of the civil suit. In other words, IA 455 was rejected and maintainability of the civil suit was upheld by the order, by another order dated 18/11/2024.
Okay.
So, my lord, maintainability and temporary injunctions were heard on the same date and judgment in order delivered on the same day. Thereafter, Lordship,
Who are you?
I am the plaintiff.
No,
We are bona fide members of the
Sumi.
Sumi community.
You are also member of Sumiho.
My lord, I'm only a bona fide member. I'm not the executive member. But from the constitution, I'll prove that I have proved my bona fide, but because all these issues were subject matter in 455.
These are addressed.
Yes, because I'm saying locus standi was also an issue.
Okay.
So, my lord, all this maintainability, so all those were heard in length by the concerned court, by the letter trial court, in these orders were passed. Thereafter, Lordship, against IA 388, that is with and 455, the present respondent had filed MAF 1 of 2024 before this honorable court.
Before this court.
Yes, MAF 1 of 2024 before this honorable court. Also, civil revision 19 of 2024 was filed before this honorable court.
Yes.
No, Lordship, in MAF 1 of 2024, my lord, the order passed in 388 was challenged.
Okay.
Now, this honorable court, by an order dated 3/12/2024, Lordship,
Yes.
allowed the revisionist appellants to withdraw because the RBT under Order 43, Rule 11R was not exhausted. Without filing an appeal before the learned district and session judge, he filed the revision petition. So in that view of the matter,
The civil suit number 23 of 24 was pending before which court?
in the court of Lordship, Civil Judge Senior Division Dimapur.
Senior division.
Senior Division. So under Order 43, appeal lies before the district in session, principal district in session judge.
Correct.
In that view of the matter, Lord, this honorable court granted liberty that you can withdraw, file before appropriate court. That is with regard to, my lord, temporary injunction. which is the subject matter in the present case. Then, my lord, with regard to Civil Revision 19 of 2024, by which the order passed in IA 455 was challenged, that is with regard to maintainability, Lordship.
Yes.
Lordship, it was the specific submission of the revision petitioners. I'll show the orders. That the prayer was that the revision petitioner should be allowed to withdraw in view of Order 14, Rule 2, Order 14, framing of issues, and to file appropriate petition, to file up and to take appropriate steps. That was a specific prayer. There was no, Lordship, this is the bond of contention. There was no specific prayer by the revision petitioner for modification, alteration, or setting aside the order dated 18/11/2024 passed in IA 455 of 2024 before this honorable court in the revision petition 19. The only prayer was that in view of Order 14, Rule 2, he should be allowed the liberty to withdraw.
Order 14, Rule 2 is preliminary issue.
Yes, preliminary. I'll come to that.
Exactly.
I'll come to that.
Exactly.
I'll come to that. I'm coming to that preliminary issues. But how the preliminary issue will be raised, I'm coming to that. I'm coming to that, Lordship.
Okay.
Now, so thereafter, court has given a liberty that this honorable court, by an order dated 3/12/2024 passed in Civil Revision 19 of 2024, did not interfere with the order dated 18/11/2024 passed in IA 388 of 2024. There is no modification, alteration, no interference in the order of granting temporary injunction. But the only observation of this honorable court was that
Approach the appropriate forum.
to approach the appropriate forum and ask him when appropriate forum is approached. Without being influenced by the earlier order of 18/11/2024, the appropriate trial court should take an independent view and pass necessary orders. That was the observation. So, my lord, the order dated 18/11/2024 passed in 388 of 2024 in my respectful submission has not been made redundant. It still stands. It still holds the field till it is interfered by or till it is recovered, if unless and until it is reconsidered.
18/11/2024
In
passed
388. Yes,
whereby temporary injunction
yes,
was
Lordship.
granted.
Yes, yes.
It is okay.
My lord, that was not
Because-
interfered by this honorable court.
Because FAO was withdrawn.
Yes, FA was withdrawn. So, my lord, FA was withdrawn, and both FA and civil revision was withdrawn with the liberty to approach the appropriate court, and in the event and in terms of Order 14, Rule 2, if the respondents raise preliminary objections in the appropriate court, then without being influenced by earlier order to take a fresh call.
Oh, that was also observed.
That is the observation. There the confusion has arisen. I'm coming to that. There is an observation there. But subject to repetition, I'm reiterating that this honorable court on 3/12/2024 did not interfere or set aside the order dated 18/11/2024 passed in 388 of 2024. Thereafter, Lordship, the respondents, instead of filing their written statement in the civil suit, raising the preliminary objections, Lordship had filed IA 589 of 2024 under Order 14, Rule 2 on 12/12/2024, which is presently sub judice. Instead of filing a written statement raising preliminary objections to be considered under Order 14, Rule 2, they filed an IA. Lordship, kindly take notes. It is IA, means interlocutory application. It is not civil miscellaneous case because IA is the word IA implies it is temporary, is interlocutory. It is not a civil miscellaneous case, nor a proper application. Because my lord, many people I have observed that for amendment of the writ petition and all that, they are filing IA. Which is interlocutory, it should be civil miscellaneous case because lordship recent indictment this morning cannot be reviewed. It is permanent. Now lordship. So the IA was found. It is pending. Thereafter, lordship, the present first appeal number 22 of 2024 was filed before in the Court of District, Principal District and Session Judge Dimapur against an IA.
No, this I could not get. Against 589,
589, my lord, it
Was
is
there
filed
a-
again for challenging the maintainability of the
14.2.
this was filed under Order 14, Rule 2, challenging the maintainability of civil suit 23
Jurisdiction or
of 23, civil suit 23 of 2024.
Okay.
Again, an IA was filed challenging the maintainability of the civil suit 23 of 2024, which is pending.
This pending.
Yes, it is pending. It is yet to be before the learned trial court. And besides filing IA 589, interlocutory application 589, the present first appeal number 2 of 2024 in the form of was filed. And lordship, it was filed before the learned Principal District and Session Judge, the Appellate Court Dimapur. During the pendency of,
Against 388.
yes, against 388. Against 388, civil, against 388, it is, your lordship is correct. Against 388, first appeal was filed on, and lordship, it was heard on 2012-2024. Thereby, a very short order was passed that the temporary injunction is vacated, the deal order will follow, and the deal order was passed on 14/1/2025. Lordship, 20th December was the last working day of the court, so maybe the court did not have time to pass a long speaking order. And accordingly, lordship, against that, these orders, I filed this revision petition.
Now you are before this court against order dated 20/12/2024.
yes.
Passed in FA 2 of
Yes.
2020.
Lordship, yes.
Okay.
Now, lordship,
Whereby the temporary injunction was vacated.
yes.
Okay.
Now, the temporary injunction was vacated only on one ground, that the learned trial court, well, deciding 388, did not consider and did not give any finding on the maintainability of the main civil suit. That is only ground. Now, lordship, I had to I have to take the option of a civil revision because lordship is well aware that under section 1042, in view of section 1042 CPC, I cannot file a first appeal because the first appeal has been exhausted. 43 has been exhausted in the.
Yes.
Now, my lord, so that is the issue involved. And lordship also may kindly take note of the fact, lordship. Lordship may kindly take note of the fact that the issue of locus jurisdiction, cause of action, alternative remedy, non-joinder of necessary parties is and maintainability is a subject matter pending before the learned trial court in IA 589.
Yes.
That aspect may kindly be taken into consideration because, Lordship, when that is pending before the original court, any order pass or any opinion should not, with due respect to your Lordship, should not influence the before the IA before the appropriate before the trial court. That Lordship, with all humility and dignity.
Any observations made in this case?
Yes, because Lordship may kindly have,
Okay, understand.
because all
That
these
as
issues,
Because maintainability issue is still pending.
Lordship,
Yes,
Lordship.
exactly, Lordship.
So,
On jurisdiction.
so those issues, she will get sufficient time. So those issues is sub judice. That may be also may kindly be keep in mind because and so that I need not repeat all those issues all over again. That's why.
But your temporary injunction was vacated only on the ground of maintainability.
Yes, I'm
So
coming to that.
without touching the ground of maintainability.
I'm coming to that point.
Exactly.
I'm coming to that point. I'll come to that point. Maintainability is already decided.
Okay.
Maintainability is already decided in 388, in 455.
455.
So from there, I'm coming, Lordship. I'm coming because when maintainability is already decided. And in fact, in 388, Lordship, in 388, in first paragraph of the order, the learned trial court has given a finding that it is a fit case for trial. That civil suit 23 is a fit case for trial. There's a finding. So I'm coming to those issues. The point, the stress will be, Lordship, that when the maintainability is already decided by the trial court, appropriate trial court, how the appellate court has come to this perverse finding in the appeal. That would be my trust of argument, Lordship. Now, Lordship, now may I go to the impugn order, Lordship, first? Lordship, may kindly go to page 149. May I, Lordship?
Yes.
Learned counsel present on behalf of the present on behalf of appellant, none present for respondent. The instant case is fixed for reply in hearing on the appeal. Hence, matter is passed over to taken up afternoon. Then Lordship, may case taken up, counsel present on behalf of the appellant and counsel present on behalf of the defendant. Heard both the counsels at length and upon hearing the counsels in also bureaus, the materials placed on record, this court is of the opinion that the impugn order dated 18/11/2024 passed in IA 388 arising is liable to be vacated and set aside. Accordingly, impugn order is set aside. The deal order shall follow. Then, Lordship, the next 151 is the order. Now, my lord, for the time being, Lordship, I'm going to paragraph 12.
Okay, 151 is the order.
Detail order, detail judgment.
FA2.
Yes,
So only FA2 has been disposed of. The
Yes.
main suit is
still pending.
Pending.
Men's suit still pending before the trial court.
Okay.
It is only on the interlocutory orders, Lordship, we are fighting.
Okay.
That is the reason why I'm saying the merit. No, Lordship, from paragraph 150, page 157, from paragraph 12 is the finding of the Learned Appellate Court.
Yes,
Merit, Lordship.
yes. Yes, please.
The order passed by the Honorable Court in Civil Revision 19/2024, in my considered opinion, have given rise to one crucial issue for consideration of this court. As stated above, White Order 3/12/2024, the appellants has been given liberty to raise preliminary issue afresh on the maintainability of the suit, and in compliance with the order of the Honorable Court, the appellate appellant's respondents has filed preliminary issue before a learned trial court. Hence, a learned trial court is once again bound to determine and decide in the preliminary issue, which in other words refers to the issue of determining the legal capacity or standing of the person to bring the lawsuit, and also in the question of the court's authority to hear hear and decide the case before. Therefore, the civil suit of the respondent, as it's done today, is pending determination of the preliminary issue on the maintainability of the suit. One of this may keep in mind. The above referred order of the Honorable High Court has, in my opinion, has given rise to new circumstance, leaving limited scope for this court to delve into all the aspects, the basis of satisfaction of the trial court upon which an order granting temporary injunction was passed. One pertinent issue that has arisen herein is whether temporary injunction can be granted prior to a preliminary issue raised by the appellants, respondents, and the maintainability of the suit. For the time being, kindly allow me to skip the judgment. I'll refer in detail the judgment, Lordship. For the time being, kindly allow me to skip the judgment referred to two judgments. I'll refer in detail by referring to the books. Paragraph 15 for the moment, my lord. Kindly allow me to jump to paragraph 15.
Para 15.
Paragraph 15. The two judgments says,
Just a minute, let me put one query. 388 and 455 were decided on 18/11.
Lordship,
On the same day, they were
Lordship.
decided.
Lordship. Same day it was heard, and that the same day it was decided.
So the question of maintainability was also decided on.
Exactly. That is the point. That is the point.
No, I'm not coming to a finding.
That is the point. Kindly allow me to make my submission. She'll get the whole day tomorrow or the whole evening after I conclude.
So your submission is, main thrust of your submission is as the 18/11/2024 judgment passed in 455, whereby
Lordship.
maintainability was decided,
Lordship.
is only put under challenge,
Yes,
is yet to be set aside.
exactly.
Therefore, this order.
Should not have been.
Okay.
That would be the thrust of my argument. Lordship has hit the bull's eye on my.
Yes, please read.
It is thus, therefore, upon considering the above cited observations in conclusion made by the apex court, this court is of the considered opinion that before granting temporary injunctions, whereby the court is firstly required to determine whether the plaintiff has a prima facie case, being the first golden principle in the court is not only required to determine whether the plaintiff has a substantial question raised bona fide, which needs investigation and a decision on merit, but also a prima facie consideration on the question of maintainability of the suit. If an objection is raised to the maintainability of the suit at the hearing of an application for grant of interim relief, the court should determine prima facie the issue of maintainability in the first instance before granting interim relief. Upon perusal of the record, it transpires that the appellants had, in reply to the IN number 388 of 2024, filed by respondents raised preliminary objections on the maintainability of the suit, locus standi, jurisdiction, besides other objections. And upon perusal of the imbued order dated 18/11/2024, passed in IA 388, the learned court below has concluded the respondent plaintiffs has a prima facie case based on the satisfaction that the respondent plaintiffs has substantial questions which needs decision on merits, and the plaintiffs have made out a, my lord, this is the point, and the plaintiffs have made out a fit case to go for a trial. This is the finding of the appellate court on the order passed by the trial court. The said impugned order of the learned counsel below does not reveal any observation recording the prima facie satisfaction with regard to the maintainability of the suit. I have also considered the rulings of the apex court cited by learned counsel for respondents and concurs that the impugned order under challenge is an interim order passed in exercise of discretionary power, therefore should not be interfered with unless such discretionary power has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principles of regulating grant or refusal of interlocutory injunctions. Be that as it may be, when the issue of maintainability, the suit arises, it goes the route raising pertinent questions under jurisdiction of the court, granting such relief in the legal capacity to sue or be sued, since the recording of prima facie satisfactions with regard to maintainability of the suit is a prerequisite for concluding that the respondent plaintiff has a prima facie case, satisfying the first principle of granting interlocutory relief. This court is of the considered opinion that in order dated 18/11/2024, granting temporary injunction is arbitrary and have also failed to satisfy the settled principles regarding grant or refusal of interlocutory applications. Then that since this court has considered and concluded that the first principle regulating granting of interlocutory injunction has not been satisfied, therefore it is considered needless to go further delve into the basis of satisfaction of the court below on the other principles regulating grant of temporary injunctions. In view of the aforesaid analysis and reason, appeal is allowed in Imbued Order 18/11/24 is hereby set aside and accordingly vacated. This is the only findings. Now, Lordship, kindly allow me for quick reference to the Constitution and then, Lordship, to the orders. I'll quickly go. Now, Lordship, may kindly come to page 33. This is the recommendation of the search committee. Now, my lord, page 34, Lordship, you can see the translated copy. Lordship, may kindly take note of the fact that the search committee is dated 25/7/2024.
Search committee.
Dated in page 33, Lordship will find it, the signed documents. Then Lordship, type copies, in translated type copies in the next page.
Yes.
In accordance with section 7.3 and such section 8 of the Sumiho Constitution, and by the authority vested upon this provisions, the office periods of the Sumiho for the term are hereby selected. The respondent number 2 is at serial number 1 as president. Then, Lordship, it was approved by the General Council on 26/7/2024. My lord, I have given a categorical statement in the petition, not disputed.
Yeah.
Then, my lord, the Constitution is an extra P starting from page 35. Lordship, I am reading from 54.
Page 54.
Yes, the English translation.
Yes.
May I read the preamble, Lordship? In solidarity with the Sumi for the protection, fostering of understanding and support among Sumis for progress and prosperity, for the protection and preservation of culture, customs, and tradition, for the promotion of peace, understanding in harmony with other tribes and races, for encouraging and supporting youth in their growth and leadership, and for instilling dignity and respect within the Sumi tribe, we the Sumi in the name of Almighty God hereby declare this amended constitution, which shall stand as a unifying embodiment of the Sumi tribe. Then Lordship may kindly see name and 1.3. Every Sumi individual shall be a member of the Sumi Ho. Then Lordship,
Okay. 1.3.
yes. Then my lord, 4.7. Aims and objective is section is 4.7. The Sumi who shall intervene in disputes only when invited by the disputing parties for resolution, as the Sumi who is not a statutory party for conflict resolution.
Okay.
Then Lordship, 5.1 and 5.2. General Assembly shall be held once every 3 years. However, the Executive Committee will have the authority to convene the General Assembly at any time in an emergency to oversee and conduct the selection of Sumi Ho office bearers and Executive Committee members. That is for the General Assembly. Then Lordship, 6.4. Duties of the General Meeting, my lord. 6.4 to submit decision resolution for approval of the General Assembly. Then Lordship, 7.1 the office bearer shall consist of the following: president and lordship 6 others. Then 7.10. Lordship is on it, 7.10. The president and vice presidents must have attained age of 50 or above to hold their positions. 7.11, to hold the position of president or vice president, the individual spouse must be of pure Sumi descendant. The 7.12, the other office bearers must have attained age of 40 years. 7.13, office bearers shall be selected or nominated from amongst the executive members. There shall be 3 vice presidents. 1 president shall be elected by the search committee. The second vice president shall be nominated by the executive committee. And the third vice president by designation shall be the president of the Western Somi Ho. Western Somi Ho, my lord, is Dimapur area. Then Lordship 7.17. May I read 7.17? The term of the office for the office bearers shall be 3 years. If deemed capable and competent, the same office bearers may serve as second and final term in the office of the Sumiho. Second and final term, Lordship.
This is being misinterpreted, Lordship. I have my own interpretation.
Yes, there is scope of misinterpretation.
Yes. She has got the whole full liberty to interpret. I have no
Whether
objection.
whether it pertains to same post or different.
My lord, I mean, yes,
It is not specifically.
yes, but this is the constitution. It is subject to interpretation, Lordship. I'll leave it to the wisdom of your lordship to interpret, but I'm only highlighting the statement. It says the term of office for the office bearers shall be 3 years. If deemed capable and competent, the same office bearers may serve as second and final term in the office of the Sumiho. My lord, my interpretation is inclusive. That is my
Any post.
any post. That is my respectful, because it says office of the Sumiho.
So if you are.
The term of office for the office bearers, lordship, it is not singular, it is plural. Office bearers. The term of the office for the office bearers. It is not singular, it is plural, so it is inclusive of all the 6 posts. That is my respectful submission. If deemed capable and competent, the same office bearers, lordship, it is plural, may serve a second and final term in the office of the Sumiho. So this is one. I'll be coming later on, but just a perusal, quick glance. Then, my lord, search committee, lordship, is section 8 and section 9, duties and functions of the president and vice president. The president, 9.1, the president shall open and conduct every meeting. Then 9.5, lordship, the elected vice president shall assume the duties of the president if the president is unavailable. So the option is there. Then, my lord, 9.7. In the event of president's resignation or death, the elected vice president shall take charge of the office until a new president is inducted. Then, my lord, 13. My lord, impeachment of office bearers and executive members. 13.1. Office bearers and executive members would be impeached if they act against the interests of the Sumis. 13.3. Any violation of the constitution of Sumiho shall result in impeachment. 13.5. And any office bearers facing a court case for wrongdoing shall be impeached. 13.6. Impeachment shall occur if a lack of integrity is found. Then, my lord, duties and powers of the executive. 14.2. The executive committee shall. 14.1. My lord, lordship queries. The executive Sumiho shall have 49 executive members. 14.2. The executive shall hold 3 assemblies each year. 14.3. The president shall issue a petition for these assemblies. It is fully within the power of the president when to call for the meeting. Then, lordship, my lord, 15 is talking about the area representatives in the executive council. Section 15.
Okay.
Then, lordship, section 16. 16.6. In the event of a dispute regarding any decision under this constitution, the decision of the executive committee shall be final and binding. Then Lordship revealed the Sumiho Constitution, which has been amended on 15/12/97, 25/1/2022, 25/2/2009, 1/12/2010, and 25/1/2023 is hereby further amended on 2/7/2021. It is declared that this constitution, having served as a guiding principle, remains in active force to this day. Then, Lordship, the Constitution Committee, Manot, the respondent number 2 is the convener. Under the under the convenership of the present respondent number 2, the last constitution was amended on 25/1/2020. 2030. Amended on 2/7/2021. So I must say that the respondent number 2 is one of the father of the constitution, because he's the convener of the last amendment committee. Now, Lordship, thereafter, Lordship may kindly come to page 62. This is an RTI reply, Lordship. This is an RTI reply to the present petitioner number 1. Your application information under RTI Act dated 30th July 2024. This has reference to your application for providing you with a list of candidates and date of birth of candidates from Olympic Higher Secondary Schools in Nepal, HSLC examination 1992 to 1994 pages. Your application was received on 3rd July 2024. I am directed to respond to your application and furnish the information in the format given in your application. Accordingly, please find enclosed the information in the format as required by you. Then list of candidates for Olympic Higher Secondary Schools in Nepal, examination 92, 93, 94. Then Lordship, serial number 7 in page 63.
Yes.
Is the respondent number 2. And date of birth, as per his admit card, is 29/6/1997 in the second last column on the right side. 29/6/1977.
If the date of birth is 29/6,
1977.
what is the age on 25/7/2024?
My lord, 49 years and a few months.
49 years plus.
Yes. In terms of this document. Not completed 50. On 26/7. Then Lordship may kindly come to page 66. The driving license of the respondent number 2. On the right hand, date of birth, 29/6/1977.
Yes.
And page 67, Lordship, this is his pension payment order of the respondent number 2. Dated, Lordship, you will find here where is it? Lordship, at page 68. Page 68. 68, Lordship has found it, part 2, page 68.
Yes.
On the left, Doc, Director of School Education, Kohima, date of birth, 29/6/1977. Lordship has found it on the left.
What is this document?
His pension payment order, Lordship. He took, well, the respondent number 2, took voluntary retirement from the school education department.
Yes, date of birth is 29/6.
Yes, 29/6/1977.
Yes.
Then Lordship, kindly come to page 69.
Yes.
This is a civil suit order dated 27/8/2024. Receive a claim from plaintiff such and such, praying for a decree declaring the result dated 26/7/2024 of defendant number 2 as President Sumiho as ab initio unconstitutional, illegal, null and void for direction to restraining the defendant number 2 from continuing to function as the president of Sumiho and disqualify him from the present position for a direction to the office of Sumiho to conduct a fresh and free election for the post of president, ensuring full compliance with the constitution and or pass any order or further orders as its honorable court deems fit in proper in the interest of justice and protect the integrity of Sumiho and welfare of the Sumi community against the defendants, the office of the Sumiho Zanipoto, Nagaland, and Sri Vihuto Asumi, counsel for the presents counsel for the plaintiff. I have gone through the plain and it is saying that this instance civil suit has been filed within the period of limitation and the cause of action arose within the jurisdiction of this honorable court. Process fee has been paid in the shape of court fee stamps. I have also perused the relevant documents enclosed along with the plain. Accordingly, on being satisfied, this case is limited and registered as civil suit 23 of 2024. Plaintiff to take steps for notice upon the defendant. Plaintiff also to furnish copy of the plain along with all relevant documents to the respondents fixing 25/9 for appearance. Then Lordship, next page.
Yes.
On 27/8/2024, the plaintiff has also filed IA 388. May I read, Lordship?
Yes. No, it only mentions about filing of.
Yes,
Or-
but kindly, my lord, I have a point to submit. That's why kindly allow me to read. So that you,
Yes, please.
present counsel for the associate receive an application for applicants plaintiff through the learned counsel under order 13-1, such and such, praying for temporary injunction, restraining the opposite parties from functioning in the office pertaining the president of the Sumiho till the disposal of the suit. I have gone through the application and at the relevant materials and all the relevant materials and satisfied. The same is admitted and registered as such and such. Plaintiff applicants to take steps for notice upon the defendants parties to show cause as to pray as to why a prayer sought for should not be allowed. Lordship, when this order was passed, the learned trial court was most fair. No ad interim ex parte injunction was issued. That point I want to highlight because many a times, Lordship has years of experience. On being satisfied, ad interim ex parte injunction, temporary ex parte injunction is usually granted. But here, the learned trial court was most fair. Notice was issued.
Yes.
Then, my lord, the next page. 71, Lordship. This is, my lord,
Injunction petition.
my lord, this is the order on 388. Lordship, may kindly see, Lordship, page 72. It is 388 order.
Yes.
Date of hearing 29/10/2024. Date of order 18/11/2024. Lordship, may kindly take note of that. My lord, I'm not going into the submissions of the parties to save time. But Lordship, may kindly come straight to page 78.
Yes.
Points for determination. 1, whether or not prima facie case has been made out by the plaintiff applicants in their favor. 2, whether or not balance of convenience favor the case of the plaintiff's applicants. 3, whether or not plaintiff's applicants are going to suffer irreparable damage. Then, Lordship, hold letter point for determination of number 1. My lord, kindly come to page 79. I'm leaving out the judgments being referred. Roman 1, Mary.
Yes.
In the case at hand, plaintiffs have filed the present Point 10 of the Sumi Constitution, which prescribed age of 50 years or above to hold the post of age of 50 years or above to hold the post of president. It is also the case of the plaintiffs that the defendant, number 2, in contribution of 7.17 of the Sumi Ho Constitution, which restrict any office bearers to a maximum of 2 terms, is currently holding the post of president of the Sumi Ho. It is the blatant case of a defendant number 2. Prior to his election as the president of Sumi Ho for the tenure 24 to 27, had served as AGS for the tenure 2011 to 23, GS for the tenure 2014 to 2017, and 2021 to 24 in the office of the respondent number 1, that is General Secretary. Going by the said assignment exceeded the prescribed limit in terms of 7.1, who for trial has been met out by the plaintiff's applicants. Since point for determining number 1 is decided in positive in favor of the plaintiffs. So, Lordship, it says a fit case to go for trial has been made out by the plaintiffs. So, my respectful submission with all humility, Lordship, the learned trial court is talking about maintainability here.
Okay.
Then, my lord, the point number 2, balance of convenience. My lord, I'm reading 81, page 81 from A. I'm skipping the judgments referred. In the case in hand, plaintiffs have been able to establish a prima facie case in their favor. On the other hand, as regards the defendant opposite party, it is said that defendant number 1 is the apex party of all the other Sumi organizations, and defendant number 2 is the president of the said organization, engaged in supporting, strengthening, preserving, safeguarding, and progressive development of the Sumi community as a whole. Hence, if injunction sought for the plaintiff is granted, inconvenience would be caused to the defendant number 1, in as much as smooth functioning of the office would be hampered without a working president. However, going by the Constitution, it is seen that in terms of 9.5 of the Constitution, the vice president is empowered to assume the duties of the president if the president is unavailable. Hence, keeping these two aspects in mind, if you make a comparison as to which party would face greater inconvenience if injunction sought for is granted, scale of inconvenience leans to the side of the plaintiffs. In view of the above, the determination of number 2 is decided positive in favor of the plaintiff. Then, Lordship, next, whether or not irreparable damage. I'm reading from A, my lord. I'm skipping the judgment. In the case in hand, the plaintiff petitioners are bona fide members of the organization and therefore has every right to protect the interests of the Sumi Ho. It is said that the plaintiffs have established a prima facie case to go for trial and also balance of convenience in their favor. Hence, the plaintiffs need to be protected against injury in terms of violation of their rights, which cannot be adequately compensated by way of damages. Hence, point for determination number 3 is decided in positive and in favor of the plaintiff's applicants. Plaintiffs applicants have been able to establish all the 3 golden principles warranting grant of temporary injunction in favor. Hence, IA 388/2024 is allowed on contest. It is hereby ordered. The defendant number 2 is restrained from continuing to function as the president of the Sumi Ho with immediate effect till the final disposal of the suit. 2, the present vice president of the Sumi Ho shall henceforth assume the office of the president of the Sumi Ho till the final disposal of the suit. This order is disposed of IA 388 on contest. So this is 388. Lordship, with your permission, kindly allow me to have a sip of water.
Yes.
Lordship, way back in 1992, I assisted my seniors in an election trial before Honorable Justice Kiani. Then he was the acting CJ of Chief Justice of Gauhati High Court. Very gentleman, very strict person. Very young, not much experience. And whole day I was translating because it was election petition witness. So without the permission of the court, the water was there on the table and it was somewhere in Gauhati, so it was so tempting. So I took a sip. And Honorable Justice Kiani scolded me like anything for not taking the permission of the court for having more a glass sip of water that day. Then Lordship, 455, 84, page 84.
Yes,
Lordship, may kindly see the date.
same day.
My Lord, kindly allow me to read in the matter of Rule 7, Order 7, Rule 1, read with Section 155 for rejection of the claim and or dismissal of the suit being non-maintainable, page 84. Then Lordship, order. Date of hearing, date of order, Lordship has sent it. Order, this order proposed to dispose 455-24 moved by the defendant praying for rejection of the claim under Order 7, Rule 11, read with Section 151 of the CPC or dismissal of the suit being non-maintainable. Then Lordship may kindly allow me my Lord, 191, reasons and decision. I'm skipping the facts of the case. Page 91.
Yes,
May I read, Lordship? 1. Having considered the rival submissions advanced by the parties, the materials placed on record, the pleadings projected in the plain, the following issues has been framed for determination. 1. Whether or not the plain discloses cause of action. 2. Whether or not the plaintiff have the locus standi to institute the present suit. 3. Whether or not this court has the jurisdiction to entertain the present suit. 4. Whether or not the suit is bad for non-joinder of necessary parties. It needs to be emphasized that in respect of defendant number 1, defendant number 1 through its general secretary has authorized defendant number 2 to plead on their behalf. Number 1, whether or not the plain disclose cause of action. Then Lordship, just to save time, Lordship 93, page 93 on the bottom.
issue number 2.
Just above that.
Okay,
Hence, issue number 1 is decided in affirmative in favor of the plaintiff's opposite parties. Lordship has found that.
yes,
Then, my lord, issue number 2, whether or not the plaintiff opposite has locus standi to institute the present suit. Lordship may kindly come to page 95, just above issue number 3. Lordship has found it.
yes,
In
Yeah,
view of the above, this honorable court is inclined to hold that the plaintiff have the locus standi to institute the present suit. Accordingly, issue number 2 is decided in affirmative in favor of the plaintiff. 3. Whether or not this court has the jurisdiction to entertain the present suit. Lordship may kindly come to page 97 on the top, above issue number 4. Accordingly, issue number 3 is decided in affirmative and in favor of the plaintiff. Lordship has found it. Then issue number 4, whether or not the suit is bad for non-joinder of necessary parties. Lordship may kindly come to page 98. Lordship on the bottom. Accordingly, issue number 5 is decided affirmative in favor of the plaintiff. In view of the above, the issue number IF number 455 is dismissed on contest. So, my lord,
no, this issue was whether or not the suit is bad for non-joinder.
yes, then Lordship may kindly say, accordingly, issue number 4 is decided in affirmative in favor of the plaintiff.
Affirmative means
Positive. In favor, affirmative in favor.
it is in favor of plaintiff, but not in affirmative.
My lord,
Question was
decided in affirmative and in favor.
affirmative means it is not bad for non-joinder.
No, Lordship, because Lordship may kindly appreciate this fact. This is,
Contradictory,
Lordship-
the order itself.
Lordship may kindly allow me.
I was
This-
satisfied, Lordship.
This petition,
Just a short minute.
this petition is filed by the defendant.
Okay. No, the court makes it clear by stating that it is in favor of the
My
plaintiff.
lord, it is affirmative, in affirmative and in favor. But the fact remains, Lordship, in view of the above, IA number 455 is dismissed uncontested.
Okay.
Then, my lord, next page, 99. Then they came before this honorable court. Now, Lordship,
Against the maintainability,
against both.
two different petitions.
Yes,
One
388 and
is
455.
MAF and one is revision.
Yes. Now, my lord, I'm reading paragraph 2.
But in this case, you are challenging only 388.
Yes, but Lordship,
It
I am
is
challenging only
connected.
388, but it is connected with 455 because question of maintainability. That's why I have to show this. This is an appeal under provisions of Order 43, Rule 1R of the Code of CRPC, challenging order dated 18/11/2024, passed by the Learned Civil Judge Senior Division Dimapur in the deliberatory application 388, arising out of Civil Suit 23 of 2024. Then, my lord, thereafter, Lordship may kindly allow me to come to paragraph 5 and 6. Paragraph 4, 5 and
Yes.
6. Very Lord.
Just.
Taking
Yes.
into account,
There are four.
yes, 101.
Yes.
Taking into account the above, Ms. Zimomi, the learner counsel appearing on behalf of the appellant, submitted that she would like to withdraw the instant appeal to file it before the appropriate court. She, however, submits that during the period which the instant appeal was pending before this court be excluded while computing the period of the petition. In addition to that, the learner counsel further submitted a registry directed to provide her a certified copy, which have been enclosed with instant memo. Taking into account the above, the instant appeal stands closed on withdrawal. The appellants herein are given liberty to file appeal against the order dated 18/11/2024, passed in IA 388 of 2024, arising out of Civil Suit 2324 before the appropriate forum, that is the Court of District and Judge of Dimapur. The court further observed the period from 2011/2024 till date be excluded while computing the period of limitation. So this is the third order. Then the next one, 103, Lordship.
Yes.
May I read? I'm reading from paragraph 2 onwards. This is an application filed under section 115, challenging the order dated 18/11/2024, whereby the application so filed by petitioners under Order 7, Rule 11 of the Code of Civil Procedure of the Plain was rejected. Ms. Zimomi, the learned counsel appearing on behalf of the petitioners, submitted that taking into account the provisions of Order 7, Rule 11 of the Code of Petition of the court, the petitioner would not like to praise the instant revision application. Rather, the issues which have been raised would be raised before a learned trial court in the form of preliminary issues, so as the same can be adjudicated upon in terms of Order 14, Rule 2 of the court. Now, Order 14 will come into play. This court has duly heard the learned counsels appearing on behalf of the parties. Taking into account the submission made by the counsel for the petitioners, this court closes the instant revision application. The closing of the instant revision application shall not constitute a bar to the petitioners or the defendants in the suit to raise preliminary issues to the maintainability of the suit. This court further observes the learned trial court shall decide such preliminary issues without being influenced by the order dated 18/11/2024, passed in IA 455 of 2024, arising out of Civil Suit 23/2024. It is further ordered that if preliminary issues are raised, the same shall be decided in accordance with law. Lordship, kindly pause here for a moment. The specific prayer of the counsel for revision is that he should be given opportunity to raise the preliminary issues in terms of Order 14, Rule 2. There was no prayer by the counsel for the revision petitioners for modification to set aside the order of 388. Simple prayer was, kindly allow me to withdraw so that I may go and raise necessary objections before a trial court in terms of Order 14, Rule 2. So that was allowed. So this honorable court did not interfere with the temporary injunction granted by the learned trial court and 388 of 2024.
Either it interfered in 388, not 450.
Exactly, both. Neither interfered in both, because first was withdrawn with the liberty to file before appropriate court. Here also not interfered. And nor it is the prayer of the revision petition to interfere. Because the specific prayer in paragraph 3 is that to give him the preliminary liberty to raise preliminary objections before the appropriate court, before the learned trial court, in terms of Order 14, Rule 2.
Okay.
And Lordship may kindly see paragraph 5, the observations. May I read again, paragraph 5. The closing of the instant civil revision which the application shall not constitute as a bar to the petitioners who are defendants in the suit to raise preliminary issues to the maintainability of the suit. This court further observes that the learned trial court shall decide such preliminary issues without being influenced by the order dated 18/11/2024 passed in IA such and such. It is further ordered that if preliminary issues are raised, the same shall be decided in accordance with law. So this is the only observation. That liberty is given, and with all fairness, this honorable court give an observation that if preliminary issues are raised under Order 14, Rule 2, without being influenced by the earlier order, you take an independent decision.
Yes, this
Without
order,
being-
this order of this court says in the gist is that while deciding question of maintainability, res judicata would not apply.
Exactly. Lordship,
That has been stated.
exactly. Then Lordship may kindly see, thereafter, Lordship, come to page 147.
Yes.
This is order dated 12/5/2024. Present case report put up, present learner council, also present. The learner council of defendants has moved an application under Order 14, Rule 12 CPC on the maintainability of the civil suit. The same is admitted in registered as IA 589 of 2024. I have gone through the order dated 3/12/2024 passed by the Honorable such and such, wherein Civil Revision 19 of 2024, wherein the learner council of the petitioner submits the taking into account the review of the provisions of Order 7, Rule 11 of the CPC. The petitioner would not like to press the instant revision application and would prefer an application in terms of Order 14, Rule 2 of the CPC before the trial court in the form of preliminary issues. Copy of the order has been served to counsel of the plaintiff. Learner counsel of plaintiff submit at the same time will be given to the plaintiff to put through IA and also fight the written objection if any. Then it is presently sub judice. Now, Lordship, though it is a very, so your Lordship is well versed, kindly allow me to refer to Order 14, just to remind ourselves,
CPC.
CPC.
Yes.
Lordship married.
Yes, Order 14.
Settlement of issues and determination of suit on the issues of law or on issues agreed upon. 1. Framing of issues. Issues arises when a material proposition of fact or law is affirmed by the one party and denied by the other. 2. Material proposition are those proposition of law or fact which a plaintiff must allege in order to show a right to sue, or defendant must allege in order to constitute his defense. Each material proposition affirmed by one party and denied by the other shall form the subject matter of a distinct issue. Issues are two kinds: issues of fact, issues of law. 5. At the first hearing of the suit shall, after reading the plain and the written statements, if any, and after examination under Order 2 of the Rule 10, and after hearing the parties or their pleaders, ascertain upon what material proposition of fact or law the parties at variance, and shall thereupon proceed to frame and record the issues on which the right decision of the case appears to be dependent. Lordship, the point I'm making is Order 14. In fact, Order 14.25 Order 14.15 also clearly shows that the framing of issues comes under filing of plain and written statement.
Yes.
Then, my lord, 14(2), court to pronounce judgment on all issues. 1, court to pronounce judgment on all issues. 1, notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of sub-rule 2, pronounce a judgment on all issues. 2, where issues both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, or it may try the issue first if that issue relates to the jurisdiction of the court. Part B, a bar to the suit created by any new for the time being enforced, and for that purpose may, if it thinks fit, postpone the settlement of the other issues until after the issue, until after that issue has been determined, and may deal with the suit in accordance with the decision of that issue.
That is preliminary issue.
Yes. So, my lord, my respectful submission is. My lord, my respectful.
They have not filed WS.
No. No WS has been filed till date. No WS has been filed because my understanding of the order of this honorable court in civil revision 19 was that, well, you want to withdraw? Okay, you withdraw and liberty is granted, that you file your written statement. And in your written statement, you can take the maintainability as a preliminary issue. And if that issue is taken in your WS, then without being, it will not be treated as a res judicata and decided afresh. That was the sum substance. That is my humble understanding of the order of this honorable court. Now, my lord, without filing, making a submission, sincere submission.
You may be right also,
I may be right also.
because
Yes.
both of you are assisting. court.
Yes, ultimately, my lord, it will be decided in the right perspective. So, my lord, by respectful submissions, instead of, because the question of limitation also will play for filing written statement.
Your submission, is it your submission that this plea of jurisdiction can be taken only by filing a written statement?
My lord, the point is, that is what the order of this honorable court is in civil revision. Because jurisdiction, lordship, we kindly appreciate this. Jurisdiction is already decided in 455. IA 455 by the trial court. So that is holding.
Trained after
Exactly.
considering the
Exactly,
pleadings of the parties.
exactly.
If some of the issues are of such nature that they can be decided before other issues,
Exactly,
then those issues are to be decided.
exactly. Lordship, no dispute. No dispute on that. That is what the law says. My only respectful submission before the honorable court is that instead of filing a WS, it is in the wisdom of the respondent. I have no comments. But the mediation also will play in not filing WS. Without filing a WS, lordship, an IA for under order 14 rule 12, IA 589 was filed, which is the same thing, where the same issue which was decided in 455 is again raised.
Okay. This IA is
89. Page 147. For it, IA
489 or 589?
580, I'm sorry, 589.
589.
Yes. So I have the same issue which was raised in 455 is again raised again in 589, which is sub judice before the learned trial court. And lordship may kindly take note of the date. It was filed on 12/12/24.
No, 589 was directed against which order? 455 or 388?
388, lordship.
388.
Yes.
Okay, in
Because
588,
lordship, we kindly appreciate this fact. your lordship is, kindly allow me to explain a little bit on this. 388 is with regard is the matter relating granting of temporary injunction. 455
Yes,
relates to maintainability.
yes.
And lordship approaches the honorable court, and this honorable court has given them liberty.
Both are withdrawn.
Both are withdrawn with liberty. So accordingly, against 455, against the issue raised on the question of maintainability, lordship, 589 was filed afresh.
That is pending.
That is pending.
And FA2 is
It is against 388.
388. Against FA2, you have approached this.
Yes, against 388. FA2 is
But in
against 388.
FA2 order also,
Because
the question of maintain on the basis,
yes, because what the respondent has done, the file 589 against 455, against 388, the file FA2. So this is the issue. Now lordship has, then lordship from 149, lordship has seen the impugn orders of the learned appellate court. Now, the appellate court has decided the issue only on one ground, lordship has seen. That is, not subject to
maintainability question was not
maintainability
discussed.
question was not considered while disposing the interlocutory applications by the learned trial court. That was the issue. Now, lordship may kindly appreciate this fact that the two petitions were filed, heard together. 388 and 455 were heard together on the same date, and by the same date, the judgment was delivered. So, my lord, the learned trial court had considered the granting of temporary injunction on the ground of three golden principles of prima facie, balance of convenience, and irreparable loss, and also give a specific finding that it is a fit case to go for trial. And since IA was, the respondent also has filed objection, but specifically in IA was filed challenging the maintainability on the 4-5 grounds that I was mentioning. So there, the maintainability was upheld, considered, and maintainability was passed in the favor of the plaintiff. So, my lord, when the impugn orders were passed by the concerned trial court on 18/11/2024, lordship, maintainability was considered and decided in favor of the plaintiff in a separate IA. In fact, maintainability was also taken into consideration by the learned trial court in 388 also, but since a separate IA of 455 was filed, it was heard on the same day, and those separate order was passed. Lordship may kindly appreciate this fact that IA 388 and 455 are both arising out of Civil Suit 23, same subject matter. So, my lord, in that perspective, whether there was any justification or any reasons based on material records for a learned appellate court to come to a finding, lordship,
Which para is that finding?
my lord, from paragraph 11, 12 onward, kindly allow me to read again so that your lordship will appreciate.
This time you come to directly to that maintainable.
Yes, lordship may kindly see
15.
15, paragraph 15 onwards. Paragraph 15 onwards. May I read again, my lord?
Only para 15.
It is therefore upon considering the above cited observation and conclusion made by the apex court, this court is of the considered opinion that before granting temporary injunctions, whereby the court is firstly required to determine whether the plaintiff has a prima facie case, being the first golden principle, and the court is not only required to determine whether the plaintiff has a substantial question which raise bona fide, which needs investigation and a decision on merit, but also a prima facie consideration and the question of the maintainability of the suit. If an objection is raised to the maintainability of the suit at the hearing of an applicant for grant of interim relief, the court should determine prima facie the issue of maintainability in the first instance before granting interim relief. Then Lordship, may kindly allow me to read the last paragraph, 17.
Yes.
I have considered the rulings of the apex court cited by Learned Council and concurs that the imbued orders under challenge is in an interim order passed in exercise of discretionary power, therefore should not be interfered with unless such discretionary power has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the absolute principle of regulating grant or refusal of interlocutory injunction. Be thus as it may, when the issue of maintainability the suit arises, it goes to root, raising pertinent questions under jurisdiction of the court, granting such relief in the legal capacity to sue or be sued. Since the reporting of prima facie satisfaction with regard to maintainability of the suit is prerequisite for concluding that the respondent has a prima facie case, satisfying the first principle for granting interlocutory relief, this court is of the considered opinion that the order dated 18/11/2024 granting the injunction is arbitrary, have been and have also failed to satisfy the civil principle regarding grant of or refusal of interlocutory application. And since this court has considered and concluded the first principle regulating grant of interlocutory injunction has not been satisfied, therefore it is considered needless to further delve into the basis of satisfaction of learned court below on the other principle regulating grant of temporary injunction. So that is the only issue of maintainability. Now, Lordship, in paragraph 13 and 14 of the judgment.
Yes.
The learned court below has relied on two judgments, which says that when maintainability is raised, maintainability should be decided first before issuing any temporary injunction. Now, on this point, Lordship, kindly allow me to highlight and distinguish this judgment, because in my respectful submission, it was wrongly applied by the learned court below. I will try to distinguish.
Yes.
My lord, in paragraph 15, in paragraph 13, Asma Latif and Shabir Amit, 2024 for SEC 696 50 to 51 is referred. Now, my lord,
Yes.
2024 for my lord, I'm relying on paragraph 8. Lordship, we call it note of the paragraphs. Paragraph 8, 11, 10, 11, 12, 49 to 51.
Just a minute.
Now, Lordship, can you allow me to read paragraph 8, which is in
You're relying on para 8,
para 8, 10,
10,
11, 12, 49 to 51.
49 to 51. Yes.
I'm reading paragraph 8, may I?
Yes.
The appellant asked plaintiffs through your power of attorney holder institute a civil suit before the trial court under order section 38 of the Specific Relief Act. The appellant prayed for permanent injunction against the three defendants from interfering with the appellant's peaceful position of the suit. 11. In the suit, an application for interim injunction was filed by the appellants. The trial court on 31/5/1990 allowed the application and directed the Kazmi and Saimala to maintain status quo with regard to the suit property and directed not to interfere with the appellant's peaceful position thereof. Then 11 is relevant, my lord. Kazmi filed his written statement in the suit on 5/12/1990, where the inter alia contended that the suit was barred by section 331 of the UPZA NLR Act and not maintainable before civil court, since the property was Bomdari land. It was further averred that the suit was barred by section 41H of the Specific Relief Act. So, my lord, there is a specific power in the UP Act specific power for civil suit, filing civil suit. So in written statement, that preliminary objection was taken under maintainability. Then paragraph 12. Upon the appellants moving an application under Rule 5 and 10 of the Order 8 CPC for pronouncement of judgment against Saimala, the same was allowed to the trial court by the order dated such and such, which we propose to avert in course of analysis. And subsequently, the trial court on 10/10/1991 framed 11 issues for consideration of the suit, of which the very one was under competency to try the suit. So, my lord, under Order 14 rule, under 14, the rule was issues were framed, including the maintainability.
After WS.
After WS, after WS. Then Lordship, may kindly come to page, paragraph 49.
Mr. Masha, I'm
Lordship.
taking some water with your,
Lordship, please.
yes,
Paragraph 49 onwards is the finding. Paragraph 49. May I read, Madam?
para 40.
Paragraph 49 to 51, I'm reading that. May I read, Madam?
Yes, please.
What follows from a conspectus of the aforesaid decision is that jurisdiction is the entitlement of the civil court to embark upon an inquiry as to whether the cause has been brought before it by the plaintiff in a manner prescribed by law, and also whether a good case for grant of relief claim has been set up by him. As and when and such entitlement is established, any subsequent error like delivery of judgment would be regarded as an error within the jurisdiction. The inquiry as to whether the civil court is entitled to entertain and try suit has to be made by it keeping in mind the provision of Section 9 of CPC, my lord, jurisdiction, Section 9 of the CPC, jurisdiction of court in res judicata. Section 9 of the CPC in the relevant enactment, according to the objector, powers a suit needless to observe. The question of jurisdiction has to be determined at the commencement and not at the conclusion of the inquiry. Although not directly arising in the present case, my lord, this is an opinion. We also wish to observe that the question of jurisdiction would assume importance even at the stage a court considers the question of grant of interim relief, where interim relief is claimed in a suit before a civil suit, and the party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that if it is barred by law and also contains on that basis that the interim relief should not be granted, grant of relief in whatever form, if it ought to be proceeded by a formation and recording of at least prima facie satisfaction that the suit is maintainable or that it is not barred by law. My lord, that has been fulfilled in the order of the trial court. Such a satisfaction resting on appreciation of evidence in the plain, the application for interim relief and the written objection thereto, as well as the relevant law that is cited in support of the objection would be part of the court reasoning of a prima facie case having been set up for interim relief, that the balance of convenience is in favor of the grant and non-grant would cause irreparable harm and prejudice. It would be inappropriate for a court to abstain from recording its prima facie satisfaction in the question of maintainability, yet proceed to grant protection pro term on the assumption that the question of maintainability has to be decided in a preliminary issue under Order 14, Rule 2 CPC. That would amount to an improper exercise of power. If the court is of the opinion at the stage of hearing of the application for interim relief that the suit is barred by law or is not otherwise maintainable, it cannot dismiss it without framing a preliminary issue after the written statement is filed, but can most certainly assign such opinion for refusing interim relief. However, if an extraordinary situation arises where it would take time to decide the point of maintainability of the suit and the non-grant of protecting pro tem pending such decision would lead to irreversible consequences, the court may proceed to make an appropriate order in the matter indicated above, justifying the course of action it adopts. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or undue hardship to the party claiming the relief, and to ensure that the proceedings are not rendered infructuous by reason of non-interference by the court. So, my lord, exception is given in the sub-paragraph that to the court on exceptional circumstances by giving justification and reason can pass interim, can pass temporary injunction without even considering the maintainability. That is the exception of the last 10 lines here. Then 51, turning to the facts of the present case, Kasmi had challenged the maintainability of the suit in the written statement filed by him before the trial court, contending inter alia that the suit property was from Madari Lane, owing to which suit was part by section 331 of the such and such, as well as it is part under section 41H of the Specific Relief Act, and thus not maintainable before the civil court. What is required of the trial court in such situation was to record a satisfaction, at least prima facie, that the suit was maintainable, and then proceed to pass such orders as it considered proper in the circumstances. A glance at the order dated 5/8/1991 is sufficient to inform us that the trial court to have, in no words whatsoever, made any decision on whether it is entitled in law to decide the plea before it or prior to declaring the suit against against Saimola under Order 8, Rule 10 CPC. Order 8, Rule 10 CPC is relating to return of claim. The question of competence to try the suit we have found was the first of several issues arising for decision in the suit, and despite such looming presence of an important issue before the trial court, which if examined and answered in favor of Kasmi would have ousted jurisdiction, it preferred not to wait and proceed to decree the same against Saimola without a whisper on its competency to do the same. This is relied upon by the learned appellate court below. Lordship, this 2024 judgment clearly deals with there is a specific power under the Act ousting civil jurisdiction, civil court jurisdiction, so that preliminary issue was raised in the written statement. And without considering that, under Order 14, Rule 2, order was passed. That's how the Honorable Supreme Court interfered. In here, Lordship will also kindly appreciate this fact that IA was filed for temporary injunction, and that was granted. There was no counter IA being filed challenging the maintainability. Here, my lord, I filed an IA for interim injunction. He filed a counter IA challenging the maintainability, and it was heard together. In this 2024 judgment, there is no IA filed by the other side challenging the maintainability. That is the distinction. Then, second case, Lordship. (2022) 5 GLD 864 was relied upon by the learned trial court. (2022) 5 GLD 864. Lordship, the relevant paragraph is, I'm relying on paragraph 2, paragraph 3, paragraph 6, paragraph 8, paragraph 9, paragraph 18, paragraph 19, paragraph 20.
Yes.
May I read, Mother?
Yes.
Paragraph 2. This is an appeal under Order 43, Rule 1(3) of the Directed against the order dated 26/2/2022, passed by the in case numbers 32 of 2019, passed by the Court of Learned Civil Judge Jorhat, whereby the courts restrain the appellant herein from entering the suit land or from disposing the suit land or any other person except the petitioner until the disposal of the suit. At the outset, the learned counsel for the appellant submits that the appellant is not aggrieved by the portion of the order to that effect by which there was an injunction restraining the appellant from disposing of the suit land till disposal of the suit. The appellant submits that the appellant being a possession of the suit land. The injunction order directing the appellant not to enter into the suit land has seriously affected the appellants, and it is for that reason that this instant appeal has been preferred. Then, my lord, paragraph 6. Subsequent thereto, on 9/7/2018, a legal notice was issued by the plaintiff to the defendant, inter alia, to come forward for registration of the sale deed and to obtain the NOC from the competent authority after receiving the balance consideration amount, and intimate that the plaintiff's date on which the date of sale would be registered within 1 month from the date of receipt of the notice, failing which legal remedies would be initiated. Subsequent thereto on 23/4/2019, a suit was filed seeking specific performance of the agreement under dated 1/3/2011, along with other consequential reliefs. The suit was registered and numbered as title suit number 34/2019. Along with the suit, an injunction application was also filed, which was registered and numbered as miscellaneous 32/2019. By way of the said injunction application, the plaintiffs sought for an interim temporary injunction to restrain the defendant opposite party to enter into the suit lane and not to disturb the peaceful possession of the plaintiffs. And further, that the defendant opposite party shall not dispose the suit land to any person except the plaintiff. Paragraph 8. In the written objection filed to the injunction application, various preliminary objections were taken regarding the maintainability of the suit for which plaintiff were not entitled to injunction. Paragraph 8. Lordship, here in this present case, this case under order 39 was filed for temporary injunction. A written objection was filed challenging the maintainability, but there was no counter petition like in the present case challenging the maintainability. Now, my lord, trial court after hearing the parties, paragraph 9. Trial court after hearing the parties, via order dated 26/2/2020, allowed the said injunction application filed the plaintiff thereby granting injunction as already stated in above. Then, lordship, can you allow me to come to paragraph 18?
Yes.
Now, coming to the judgment of the learned trial court, it transpires that the court below did not raise the issue of maintainability of the suit, which was duly raised in the written objection filed by the defendant on the ground that the suit was barred by the mediation. This court at this stage would like to refer to the judgment in Sri Kumar Chandam of the Municipal Corporation of Delhi. Temporary injunction it need not be said that temporary objection of filing a suit challenging the validity of the order of demolition is to restrain such demolition with the intervention of the court. In such a suit, the plaintiff is more interested in getting an order of interim injunction. It has been pointed out repeatedly that a party is not entitled to an order of injunction as a matter of right or course. Grant of injunction is within the discretion of the court, and such discretion is to be exercised in favor of the plaintiff only if it is proved to the satisfaction of the court that unless the defendant is restrained by an order of injunction or an irreparable loss or damage would be caused to the plaintiff during the pendency of the suit, the purpose of temporary injunction is thus to maintain the status quo. The court grants such relief according to legal principle ex tupitu judicia. It means, my lord, as a tip of justice or in accordance with the requirement of justice or as a matter of right, the Latin meaning. Therefore, any such order is passed, the court must be satisfied with a strong prima facie case has been made out by the plaintiff, including on the question of maintainability of the suit, and the balance of convenience is in his favor, and refusal of injunction would cause irreparable damage. 19. From the perusal of the above quoted paragraph of the said judgment, it would be clear that the maintainability of the suit has to be taken into consideration at the time of ascertaining as to whether a prima facie case was going to trial. The judgment passed by the trial court clearly does not take into account this said aspect of the matter. Now coming to the question as regards who is in possession, it appears from the perusal of the impugned judgment, and more particularly in the penultimate page of the said judgment, the trial court reports that there is a dispute as to who is in possession of the suit land. Accordingly, the honorable court interfered. Now, my lord, and Lordship may kindly appreciate this fact that 1993 3 SEC was referred. In the present case, Lordship may kindly allow me to refer to this case, just to show the facts. My lord, 1993 3 SEC 16. 161.
How you are distinguishing this?
That
Yeah.
here also there is a specific, my lord, the Lordship 2022 of that Supreme Court judgment. 1993 Lordship.
2022.
Lordship, I'm making a distinction that in this particular case in the GLD 5, An IA was filed for temporary injunction, and a preliminary objection was raised on the maintainability
India AIDS.
in the IA itself. And without taking into that consideration, order was passed. In the present case, Lordship, the learned trial court has also passed an order that it's a fit case for trial. And view of the fact that 455 was filed, maintainability was also heard. So that is a distinction. Here, only one IA under
Which-
order 39.
Which one?
In
the IA itself, the question of maintainability was raised,
yes,
but that was not considered.
yes,
In the instant case, a separate IA was filed and that was considered.
yes. That is a distinction I'm making. And the learned High Court in 2022 5 GLD has relied upon 1993 3 SCC 161. So here also, Lordship, may kindly see at paragraph 7.
Para 7, yes.
Yes, Lordship, may kindly. Lordship has found it, paragraph 7.
Yeah.
And 347A, power of jurisdiction of courts. So, my lord, under the Delhi Municipal Corporation Amendment Act, there was a
Specific.
specific power, so that maintainability was raised. So-
In the instant case, what is the question of jurisdiction? What question has been?
My lord,
Lordship,
jurisdiction was raised.
clarify.
Jurisdiction was raised.
Let him,
Jurisdiction was raised.
Because
Jurisdiction.
it's touching the main crux of the
No,
case.
because I'm coming,
We are not,
I'm coming,
this
I'm
is
coming
wasting the
I'm
court's time.
coming to that. My lord,
what question of jurisdiction?
jurisdiction was raised on the ground that Lordship, that the case that the dispute arose in Zunipoto.
Everything.
Zunipoto, all the issue arose in Zunipoto. Accordingly, the matter should not have been filed in Dimapur, under Dimapur jurisdiction. Jurisdiction was raised on that ground. Now, my lord, what is happening is here, the respondent, number 2, is a permanent, is running a business in Dimapur. As per the report, he's running a business in Dimapur, and there's a clear finding by the respondent, by the learned trial court, that he was running a business in Dimapur, has got his own land and a certificate was issued by Gangbara of his village that he's a permanent resident of a village in Dimapur. So on that ground,
That has been withdrawn.
my lord, on that ground, jurisdiction was upheld. My lord,
Okay.
that was upheld by the learned trial court, and that is
The
before the,
question of territorial jurisdiction was.
yes,
raised.
only the question of territorial jurisdiction, not a specific power by any legislation. No, any specific power by any act or any law form. Only on the question of territorial jurisdiction, preliminary objection was raised. So, my lord, I'm only trying to distinguish two judgments relied upon by the learned trial court. In fact, lordship, the 2024 judgments is in favor of the plaintiff because it is talking about a case where preliminary objection has to be raised under order 14, rule 2, true written statement. That has been clearly mentioned in paragraph 49 to 51 of 2024 judgment, which we have relied upon. Simon, that Asma Latif case, 2024 for SCC 696. Now, lordship, on the issue of, my lord, kindly allow me to refer to the judgments and I'll sum up all these issues together.
Yes.
Then, my lord, on the issue of discretion of the court to grant,
No, before that, one query.
lordship, please.
In this case, in IA 455, the temporary injunction was prayed for by you. 388. 388.
Lordship,
The petitioner prayed for temporary injunction.
lordship,
Whether the respondent filed any written objection.
written objection was
In
filed.
that written objection, whether separately question of maintainability was.
Yes, it was raised.
In addition,
Uh,
in addition to IA 4,
Yes, it was
55.
raised.
it was also raised.
Yes, it was raised. That's why, lordship, on that point, that's why, my lord, that is why, my lord, that is why, my lord, in 388, the lordship may kindly see in 388 order at
No, you have, we have already,
388, page 80, that's why, my lord, I was making a submission. Preliminary objections on the maintainability was raised in the written objection, no dispute in 388. Then also, whereby at page 80, I was mentioning to the court, this honorable court, of the judgment order, that it says
fit case for trial.
a fit case, a fit case to go for trial has been made out by the plaintiffs.
Where, according to you, this is where the question decides the question of, the court
Maintain-
decides the question of
Maintainability. That is what I'm trying to convey, Lord. Over and above the order in 455. Because if this word is not missing, then issue picture would have been different as asked by this honorable court. But taking, my lord, kindly allow me to read this. Taking into account the rival submissions advanced by the parties, the material evidences brought on record, it appears that substantial questions which needs decision on merits have been raised by the plaintiffs applicants. A fit case to go for trial has been made out by the plaintiffs applicants. Hence, point for determination number 1 is decided in positive and in favor.
So your submission is that trial court addresses the question of maintenance.
Exactly, Lordship.
Okay.
That is my submission. Over and above, 450 order passed in 455.
Okay.
And when my lord, in my respectful submission, my lord, when the detailed order is passed in 455, maybe the trial court team would fight that a short paragraph is indicating the maintainability is sufficient because it has to be was heard on the same day, delivered on the same day, on the same civil suit. So, my lord, the fact remains that no WS has been filed so far. Only 589 is pending.
When the petitioner, when the respondent appeared in the suit,
My lord,
when the suit was filed,
my lord, I do not know on which.
23 of 24.
Yes,
So it was filed in the, when?
my lord,
September
September.
27.
my lord, I'll show the order.
Your submission is over. You have completed your submission.
My lord, I'll only refer to some judgments as on discretion of the court, if your lordship deem it fit.
You have 5 minutes time. Then
Then, my lord,
otherwise it will spill over.
my lord, because
She will also take some time.
so, my lord,
It's not sometime-
let it be keep part.
You will not take much time.
So may I pray, my lord, that the matter we keep part and we continue tomorrow?
Let us consume the remaining time.
Okay, okay, okay.
But that time is not for you.
Yes, Lordship, just
Entire time is not for you.
No, my lord,
You have already almost completed your submission.
my lord, I'll be relying, I'll rely on 3 judgments on discretion.
Please cite.
Thereafter, just a short summary, then I'm concluding.
How much time will you take?
My lord, I have 10, 15 minutes, I hope, because, or if some time is very short. Not to put under tension, we continue tomorrow.
Lordship, my side also should be.
Because she will get sufficient time. Let me conclude.
This
We're
is-
not concluding the hearing today.
We have not even started the case
Yes,
and he.
no,
You take 10 minutes more.
yes,
You take 10 minutes more, then I'll hear you, and then you will continue tomorrow.
Exactly, Lordship.
yeah, because, no problem. My lord, because I'll submit 3 judgments under discretion of the court, because, my lord, interim, the temporary injunction is a, lordship is well aware the discretionary power of the trial court. So whether, under what circumstances the appellate court should interfere, only on that, I'll give
Yes.
short
please,
judgments.
Please.
Lordship, 2006, 5 SCC, 2 at 2.
7-8.
282. Para?
Yes, para 30 and 31, 32.
Please read. 30 and 30.
Mary para 30, Lordship.
Yes.
The discretion of the court is is exercised to grant a temporary injunction only when the following requirements are met out by the plaintiff. Existence of prima facie case as pleaded, necessitating protection of plaintiff's right by issue of a temporary injunction. Two, when the need for protection of plaintiff right is compared with or weighed against the need for protection of defendant's rights or likely infringement of the defendant's rights, the balance of convenience tilting in favor of the plaintiff. Three, clear possibility of irreparable damage being caused to the plaintiff if the temporary injunction is not granted. In addition, temporary injunction being an equitable relief, the discretion to grant such relief will be exercised only when the plaintiff's conduct is free from blame and he approaches the court with clean hands. 32, where the lower courts act arbitrarily, capriciously, or perversely in the exercise of its discretion, that appellate court will interfere. Exercise of discretion by granting a temporary injunction when there is no material, or refusing to grant temporary injunction by ignoring the relevant documents produced are instances of action which are termed as arbitrary, capricious, or perverse. When we refer to the acting on no material, similar to the no evidence, we refer not only to cases where there is total dearth of material, but also to cases where there is no relevant material or where the material taken as a whole is not reasonable, capable of supporting the exercise of discretion. In this case, there are no material to make out a prima facie case, and therefore the High Court in its appellate jurisdiction was justified in interfering in the matter and vacating the temporary injunction granted by trial court. One. Secondly, Lordship, 2010, 2 SCC 142. I'll refer to only one paragraph, paragraph 22.
2 SCC 142,
2, para 22.
yes.
The ratio of the page 153.
Yes.
The ratio of the above-mentioned judgment is that once the court of first instance exercised its discretion to grant or refuse to grant a relief of temporary injunction, and the said exercise of discretion is based upon objective consideration of the materials placed before the court and is supported by cogent reasons, the appellate court will be loath to interfere simply because on a de novo consideration of the matter, it is possible for the appellate court to form a different opinion on the issue of prima facie case, balance of convenience, irreparable injury, and equity. Then finally, Lordship, 2013, 9 SCC, 2013, 9 SCC, 200, page 221, para 21 and 22.
21 and 22, yes.
This is the last judgment. I'll refer only two paragraphs. Paragraph 21, page 230, Lordship.
Yes.
On the
Yes.
bottom.
Yes.
Near it. Paragraph 14 of the aforesaid judgment, which is extracted below, would amply sum up the situation Wanderlust case. The appeals before the division bench were against the exercise of discretion by the single court judge. In such appeals, the appellate court shall not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principles of law regulating grant or refusal of interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. Appellate court would not reassess the material and seek to reach a conclusion different from the one reached by the court below if the one reached by the court was reasonable, possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably in a judicial manner, the fact that the appellate court would have taken a different view would not justify interference with the trial court exercise of discretion. My Lord, 22. From the above discussion would lead us to the conclusion that the learned appellate bench of the High Court was not correct in interfering with the order passed by the learned trial judge. We wish to make it clear that our aforesaid conclusion is not an expression and opinion on merit of the controversy before the parties. Our disagreement with the real decision bench is purely on the ground that the manner of exercise of appellate power is not inconsistent with the law laid down by this court in Wanderlust. Accordingly, we set aside such and such, and while restoring the order dated 13/4/2012 of the trial court, we request the trial court or such court to which the case may be, in the meantime, have been transferred to dispose of the main suit as expeditiously as its calendar would permit, with the expectation that same would be possible within a period of 6 months from the date of receipt of this court. So these are the three judgments. Now, my lord, I will conclude. I will not take much. I will not repeat. But one, my lord, the balance of convenience is in favor of the plaintiff because, my lord, when the case was heard in the appellate stage, the fact remains that a temporary injunction was already passed strictly in terms of Order 39 by the Learned Trial Court. So balance of, in view of the judgment in favor of the plaintiff, the balance of convenience in my respective submission was in favor of the plaintiff. Accordingly, the appellate court should not have interfered. That is one I would like to add. Now, Lordship, my learned friend has been raising issue about jurisdiction in other points. My lord, at the introduction of my submission, I was beginning a submission that all those issues on the issue of jurisdiction, on the issue of locus standing, on the issue of cause of action, on the issue of non-joinder of necessary party, and then on the issue of alternative remedies, Lordship, the petitioner, the respondent, has already filed 589 in which is sub judice. And that must have been the reason why the learned appellate court did not enter into all those issues. And Lordship may also kindly appreciate the power of revision under 100 in section 115, the power of revision. Because, my lord, the learned appellate court had considered only one point, maintainability, and he says that since maintainability goes to the root of the matter, it is not necessary for him to consider the other issues and brush aside all the issues. That was in the last paragraph. So that way, Lordship, that is the issue, and I'm repeating again that, Lordship, the order passed in 455 has not been modified, had it not been set aside, it is still holding the field as of today. So it is not, in no way it has become infractious or redundant. So my respectful submission before this honorable court is that this honorable court may kindly interfere and set aside the imbued judgment in order and restore the order passed by the trial court in 388. My lord, I think, Lordship, I'm very thankful for a very patient hearing. Then after she replies, my lord, kindly give me 5-10 minutes of rejoinder if necessary.
Okay, yes, Ms. Zimumi.
May it please my lordship. At the first instance, lordship,
No, before, I just wanted to know one thing before you make your submissions. This court gave you an opportunity to raise the issue of maintainability.
fresh.
455. So you, instead of filing WS, you filed a interlocutory application.
Lordship,
Now listen to my query.
yes, lordship.
When did you appear before the trial court?
We have filed this and thereafter
Because
it is being fixed on 28.
what is happening in the suit?
Lordship, for me, those things that the learned counsel, senior counsel has submitted before this honorable court, I'm not on those issues. This is not a case where we are on merit. Merit will only come when it goes to trial, when evidence is laid, only then, Lordship, other issue, before preliminary as per law. That is the provision of law. Preliminary objection has to be overcome first, whether in the High Court or in the.
No, you have not answered my query.
Okay, Lordship.
My query was different. You have filed a interlocutory application,
Exactly, Lordship.
589. IA 589,
Lordship.
but you have not yet filed your written statement.
Yes.
Assuming that your 589 is dismissed, if it is allowed, you win the case, his case goes.
Only then my written statement will be filed.
Now,
No.
by which law you will get extension of time of 90 days?
Lordship, I pray that those are,
Those are not the matter to be discussed, but here the court is exercising power under section 227. Therefore, I raised this issue. What trial court is doing with the suit? Suppose in suit, there is a statutory limit prescribed by law
Yes.
within which you have to file written statement.
Yes.
So if your 589 is allowed, then no issue will be raised. Suppose 589 is dismissed, then which law will give you time to file WS?
Lordship, one aspect.
This is,
I pray this before this honorable court to first let me satisfy this honorable court
Yes, yes.
on those are secondary issue for me, for the respondent's lordship. And the case that has been raised before this honorable court by the learned senior counsel, they have approached this honorable court as if the case has already been decided, and as if they have come for final decree. Now what is happening is as if like in,
now,
yes, it is in.
now Mr. Tas,
I will not.
Masa,
Lordship.
Mr. Masa,
Lordship.
it is your turn to remain.
No, I
silent.
Yes,
am conversing
yes.
with the junior, not with him, Lordship. I am discussing the issue, not with him. I will not disturb. Just give an answer.
Yes.
On my part, lordship,
Because my lordship
I will
was
just lay-
briefing me on the issue. That's why I was talking to him.
on my part, I will just lay down the foundation and I will satisfy my lordship that I will convince my lordship, I will satisfy my lordship. The issue that they have submitted and my issue is very different, on different aspect. Now lordship will kindly come to, I will just start my submission from Constitution of India.
Yes.
This Simihoho, just an introduction, lordship. This Simihoho is a tribal body exercising power and authority as per traditional convention, lordship. In fact, this subject matter does not come before the civil court. In fact, why? Because lordship will kindly see they are non-governmental organization. The office of Simihoho is not an office of profit. Lordship will kindly, in the first instance, this is not an office of profit. It is a traditional body. Simi tribe consists of more than 3 lakhs. And this Simihoho body represent the whole Simi consisting of more than 3 lakhs as a tribe. Now, lordship, this Simihoho traditional body derive power and authority under Article 371A. Lordship will kindly come to Constitution under Article 371A. I will just satisfy my lordship. Just the basis foundation has to be understood. Otherwise, it will go highway, lordship.
Yes.
Article 371A. Special provision with respect to the state of Nagaland, notwithstanding anything in this constitution. 371A, lordship.
Yes.
No act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedure. This Simihoho is constituted under this Article 371A. Not only Simihoho, all the tribes in Nagaland, there are now 17 tribes, lordship. So the 17 tribes comes within the purview of Article 371, subclause 1 and 2. No act of parliament in respect of religious or social practices of the Nagas, Naga customary law and procedure. So my office, Simihoho office comes within the purview of Article 371A subclause 1 and 2, Roman 1 and 2. So my lord will kindly, this is where I am under, not under the government, not under any other organization. So I come under this, we derive under this, and under this comes the, I have already submitted previously also, Lordship. Under this, the tribal bodies, customary bodies are empowered under.
No, I am not getting you. This 371A states that constitutional provisions would not be applicable to these in respect of these
Tribal bodies,
tribal bodies or religious
conventional
practice.
bodies, Lordship. So I'm just trying to.
Unless legislative assembly by resolution decides otherwise.
Yes,
So it is a bar
So-
in applicability. So how you are bringing 371A in this
under
case?
this 371, under this, the state government is empowered and they framed the Nagaland Village and Tribal Council Act 1978. And under this, at chapter 3, the Tribal Council,
Yes. Yes.
that is speech. Tribal Council Act 24. 10, page 10, have my lordship found it. At the bottom, there is page 10.
Page, it's
Page 10, chapter 2.
section on provision.
This is Tribal Council Act,
No,
section,
pagination is not there, therefore.
chapter 2, Tribal Council.
Paste it.
Yes, page 10. 24.
Yes, 24. What it says?
Yes, under this Tribal Council, that includes all Naga tribes, council, association, organization, tribal bodies. The composition, tenure, and method of constitution of tribal councils and apex tribal councils, their power, duties, and function, etc., shall be as per the traditions, customary practices, and usages of the tribes concerned.
Okay, what do you want to say now?
Yes, what I want to impress my lordship is that we come under this provision.
So
That is,
you are saying that Sumihoho is a tribal council?
yes,
Okay,
exactly.
then what is your submission?
Then,
Assuming that it is a tribal council.
yes, this is, this provision empowers us. Now,
No, what I have understood from his submission is that Sumihoho has a constitution of its own,
that's why,
which prescribes eligibility criteria for the office bearer of Sumihoho. When one of the eligibility criteria provides for the age criteria of the president, which is violated in this case. This is the simple case.
yes, I'm coming to that, lordship. And if my lord will kindly, they have not annexed in the appeal before the learned district and session judge. I have not annexed even one document before the trial court because in a civil suit, when preliminary objection is raised and filed before the civil court, first of all, the law demands the preliminary objection has to overcome first.
I have a query.
Basing upon the jurisdiction.
No,
So
I-
I'll come to that.
I have a query on that issue.
Yes,
That how to raise preliminary objection? What is the mode of raising Can you file IA or is it whether it has to be in the WS only?
no, lordship. Preliminary objection, if when to go for trial, we write written statement, but to raise a preliminary issue on the question of law as well as on the question of fact. We filed under IA.
Where is the provision? Where is the provision? You can answer me tomorrow also.
Yes, Lordship.
Where is the
Lordship.
provision in a civil suit has to be, procedure has been prescribed by Code of Civil Procedure, where pleadings are defined, what is plain, what is written statement. The plaintiff filed his plaint alleging certain, making some averments. You have a issue of jurisdiction, say,
Yes, Lordship.
that this court lacks jurisdiction.
Lordship.
You can raise that issue in your objection to an interlocutory application under Order 39.
There is,
also.
Lordship.
That you have done. You have filed a written objection against his injunction petition. But in the suit, by which mode you will raise that objection? Apart from filing WS, is there any mode prescribed?
Lordship, to raise preliminary objection, we can file IA.
Where is the,
Lordship,
which law allows
I
it?
will satisfy my Lordship, tomorrow I will be,
Tomorrow.
tomorrow I will, Lordship. And here, Lordship will kindly come to their constitution of Simihoho.
Now, by referring to this Nagaland Village Tribal Council, which point you wanted to emphasize?
Under this,
That Sumihoho is a tribal council.
under the tribal council. This Simihoho constitution, under the constitution of India, tribal council is empowered. Then under the tribal council comes this Simihoho constitution. That is what I'm trying to impress my lordship.
Okay, assuming that it is a organization, it is a tribal council under the said act, Nagaland Village and Tribal Council Act, then what is your submission?
I will rely my case only on the constitution of Simihoho, which,
Which he has written.
yes, lordship, only that. Only that. Now, before going into the constitution of Simihoho, I will bring my lordship to, they did not annex any of my documents before this honorable court, lordship. They have suppressed the documents that I filed before the learned district and session judge. And they have annexed only the pleading portion. That's why in my affidavit in opposition, I have annexed all the documents that I placed before the learned district and session judge, lordship. And they are trying to suppress the material facts. Now, lordship will kindly come to, I have annexed even this 31, page 31, annexure 3, the civil suit itself.
Which page
31,
of your affidavit?
if of my affidavit in opposition. Now, if my lord will kindly come to the prayer portion,
Page 31.
40. But in the first instance, lordship will kindly see, I have raised this question also before the learned civil judge. Page 33, just page 33, the first cause title,
Yes,
33, my lord has found it.
yes. What is your submission?
They have approached the civil court under the constitution of Simihoho. Violation of,
Yes.
under no section, they have filed this civil suit under the CPC. There is no section in approaching the civil court under any section, and they have filed this civil suit under violation of section 7.3, 7.10, 7.17, 8.4, and 8.5 of the Simihoho Yezabo Constitution. They have approached the civil court under this section, and declaration of result dated 26 July 2024. That is oral declaration, lordship. Nominating the president of Simihoho,
Ms. Imomi,
yes.
My understanding is that they have approached civil court because they deem the dispute to be a civil dispute,
Yes, Lordship.
because they have alleged that you have in violation of
Yes,
the
yes.
provision of the constitution of Sumi Hoho, you have been elected. That is their case.
Yes.
And therefore, they have filed a civil suit. Is it your case that it is?
My case is that they don't have a locus standi. I will satisfy my lordship. Since the learned senior council has submitted so much and my lord has been,
You can take as much time as you want.
yes, lordship.
I'm not restraining you.
Yeah,
I'm only putting my query.
yes, lordship. That's why I
Don't
also will
think
try
that-
my level best to convince my lordship on the other hand and on the other aspect. So since they have approached this honorable court under the Simi Hoho constitution,
Yes.
only on that, I will base my case on the Simi Hoho constitution as well, lordship. So my Simi Hoho constitution is
Lordship,
at
may I
page.
interrupt for 1 second? It is already 4:36. Your lordship was very tired. We continue tomorrow. 4:30 is the time.
We have for 15 minutes time.
Okay,
Ah.
lordship. Yes, lordship. I am only concerned for that. No problem. Sorry for this.
At
Lordship-
least she can refer to
Yes,
some
lordship.
preliminary things.
Yes,
So that-
only preliminary things
No issue.
for my lordship satisfaction. My lord will kindly come to section.
Or Ms. Zimomi,
Lordship,
or will you continue tomorrow?
I leave it to your
In-
lordship's
in-
discretion.
You have to counter their submission.
Yes, exactly. I'll do that. I thought that we have come for revision, so I have left out all the others submission and Supreme Court cases that was used below, but I think lordship, I also have to go to back to square one again.
No. One of their main submission, to my understanding, is the Court of District Judge was wrong in dismissing, in allowing your first appeal by holding that the trial court has not decided the question of maintainability, when the trial court has simultaneously in another interlocutory application on the same day has decided the question of maintainability,
Lordship,
as well as in the impugn order also, it has held that they have a good case to go for trial. That
lordship,
you have to answer.
lordship, here I want to impress
Tomorrow.
my lordship. Just one question on that. Had the trial court's judgment order 2024, the trial court's granting injunction, temporary injunction. Lordship, had it been right, this honorable court will never have redirected and sent back the case back to the lower court to giving liberty to the petitioner to raise afresh the preliminary objection, and the lower court has been directed to hear the preliminary objection first, because that is the law.
No, trial court. This court only gave you option to file an appropriate application.
That's why,
It does not say that you have to file an interlocutory application.
Yes.
Lordship,
It has to be according to law.
Lordship, I will satisfy my lordship. I will satisfy my lordship. And had the order of the lower court been right, that preliminary objection to raise afresh would not have been ordered. What has happened is the revision petition and MA miscellaneous application first was filed together at the same time, lordship, before this honorable court. The provision of law is that when an appeal and revision are arising out of the same civil suit is before the Honorable High Court, the Honorable High Court has to hear the appeal matter first, lordship. Appeal matter has to be heard first. But since the Honorable High Court held that since there is a provision to approach the court of the district and session judge first in the first appeal, Lordship, it was pronounced in the open court. I filed this revision 2024 for quashing of the whole case that is pending before the civil suit 223 that is pending before the honorable court. My civil revision petition was for quashing of the civil suit 23 pending before the
Okay.
honorable
Okay,
court.
we'll continue.
Yes, Lordship.
tomorrow.
Yes, Lordship.
Lord Mr. Takamasha, Learned Senior Counsel assisted by Mr.
Arenlo,
R.
Arenlo. Arenlo.
Aren Long. Also heard Ms. Z. Zimomi, Learned Counsel for the respondent, sole respondent,
Yes.
the,
Two respondents.
Two respondents.
both the respondents,
Sumi Hoho and the respondent number two.
Learned Counsel for the respondent. You are also appearing for Sumi Ho.
Yes.
Yes,
one and
they
two.
are 1 and 2.
Okay.
That's
The,
why,
the hearing remain inconclusive. Let this matter be listed
For admission hearing tomorrow.
tomorrow for admission hearing as part heard matter. At a fixed time, it would be good.
Yes. Okay, Lordship.
if, Lordship,
At a fixed time.
Lordship, if you give us a time,
at-
yes,
You suggest a time, 2,
or Lord, Lordship.
or it should be in the morning.
If,
at 2, 2.
Lordship's convenience,
Lordship,
Lordship's convenience, Lordship's convenience.
No, if it is at 2, then
other matter can be
Yes,
other
finished
matter
first.
can-
Yes, Lordship,
Yes.
that
then-
is what I'm,
yeah,
at 2.
at 2.
Lord,
At 2.
much obliged.
Highly obliged, Lordship.
May I please your lordship, I'm appearing virtual lordship. I was waiting for item number 11. Somehow I probably missed it. I'll pray only to fix a date, lordship, so we could travel from Guwahati for appearing, lordship. Item number 11,
Already order has been passed.
lordship. During lunch, probably I missed out that time. Only I'll pray for a date, lordship, if that could be
11
not
is-
inconvenient.
which date you are praying for?
Any date, lordship, a date will be
Suggested
easy for us to,
Suggested date.
in April 3rd week, lordship.
Item number 8.
11, lordship, 11.
Item number 11, heard Mr. G. Deka.
Lordship, D Deka, actually. It's D
D
for
Deka.
Deep Jyoti. Yeah.
G. Deka, Lanet Khan. Date reassess fix करना. Let the matter be
April
Third.
3rd week, lordship.
third week of April on a date to be fixed by registry.
Lord, oblige, lordship.